The recording's going, Dan. We can start at any time.
All right, well then let's begin. Good afternoon. Today is the first day of our 2020 fall seminar, which like most things happening now is brought to you virtually. I am Dan Larson. I'm a shareholder at the Buchalter Law Firm and a member of the board of directors of OADC, and I'll be monitoring today's events. Typically, the fall seminar is a one-day event in Portland. That includes exhibitors who sponsor our OADC events throughout the year. And many of our vendors have significantly felt the impact of COVID, as you can imagine. And prior to each session, we're going to be providing one of our sponsors an opportunity to talk about their respective business and how they might be able to support your needs. And at this moment, I'm going to ask Lane Rockford with Rockford Investigations just to say a few words. Please, Lane.
Good morning, or afternoon, I guess. I'm Lane Rockford with Rockford Investigations. Thank you, OADC, for including me in the seminar today. Rockford Investigations is a full-service firm specializing in surveillance investigations. We cover insurance defense, workers' compensation, domestic-related issues, and much, much more. Our strengths are working with full communication and teamwork with each and every client, followed by our covert and equipment skills. Our surveillance team has over 30 years of combined experience. We are bold, we're aggressive, and we get results. Please contact me if you'd like to hear more about our results. I would love the opportunity to work with you. Thank you for your time. It's been a pleasure talking to you, and stay safe.
Thanks very much, Lane. Thank you for your support of OADC. I'm now pleased to introduce our distinguished presenters for our first session today regarding socially distanced discovery and challenges confronting the parties and the court. Our first is the Honorable Stephen BUSHONG, who's been a circuit court judge in Multnomah County since 2008. He was named Chief Civil Judge in 2013 and presiding judge in 2018. Before becoming a judge, he started his career at the Miller-Nash firm and moved to the Oregon Department of Justice, where he held a position as Assistant Attorney General, attorney in charge of Special Litigation Unit, and Chief Trial Counsel of the department's Trial Division. Judge BUSHONG has also authored several chapters and OSB publications, and he is submits regularly to the recent significant Oregon cases feature in the Oregon State Bar Litigation Journal. Next is Elizabeth Falcone, who's a shareholder with OGLETREE, DEAKINS, NASH, SMOAK, and STEWART. Ms. Falcone represents private, public employers in all aspects of employment law, including wage, hour matters, wrongful termination, discrimination, and harassment litigation. She has experience defending class action cases as well as single and multi-plaintiff cases. She's tried cases for employers in state and federal courts. And she also has experience in traditional labor law, including handling grievance arbitrations and collective bargaining, as well as advising employers with unionized workforces. I have actually truncated these descriptions because our speakers have so many more accolades that we don't have time. So we're going to move straight to our presentation. And I want to thank them both for being willing to participate via Zoom. And excuse me, and they will field your questions throughout the CLE, but I will monitor the chat room that will allow for your questions to be seen, and we will break at appropriate times during the presentation to present your questions for the speakers to address. Please feel free to submit your questions at any time, and we'll try to answer as many as we can, but due to limited time available, we may not be able to get to all of your questions. We're applying for CLE credits, and we're recording this presentation, and we'll be making it available at a later date. We plan to circulate the presentation materials and details how to receive CLE credit and our contact information via email after the webinar. With that, we will start the presentation. I turn it over to Judge BUSHONG and Elizabeth Falcone.
Thank you very much. this has been, I think, an unprecedented time for most of us, with things changing every day. And what Judge Bushong and I are hoping to do is I'm going to give some thoughts on things that the lawyers are struggling with, and Judge Bushong is going to give some his thoughts in terms of what the courts here are doing. Can everyone see my the PowerPoint that I brought up? Is that visible, Dan?
Yes, it is. Sorry, I had my muted. I can see it. It looks good.
Great, good. I just wanted to make sure. So to start off with, I wanted to bring up the fact that I have spent a bunch of time collecting resources from across the country about how courts are dealing with these types of situations presented by the pandemic, whether or not they've had to adopt interim rules or whether they've had to be flexible. And I, as somebody who's practiced in a number of jurisdictions over the years, I think that Oregon has some of the best rules of civil procedure in terms of the fact that they already provided for flexibility. And so one of the things that, has struck me is how many courts I've seen that have to issue interim orders, that have had to, for example, many states, many jurisdictions did not allow remote swearing of a witness, and it had to be done in person. The court reporter had to be able to be present with the individual and verify their identity. And here in Oregon, I think we are in good stead because the rules in many ways provided the type of flexibility that was needed. Your Honor?
So I wanted to emphasize the rules of civil procedure because they set the default. The rules are going to govern, and if the parties don't agree on something, then when you come to court with some issue, the court's going to rely on the rules. And so, the rules were never intended to govern during a pandemic. And so we really need lawyers to exercise the highest level of professionalism in dealing with each other, being creative, keeping your cases moving. Don't just rely on the rules, just know that the rules are there and provide the default. So under, Rule 36, there's 4 methods by which you can obtain discovery. It's listed in the rule. That doesn't mean those are the only ones. You can agree to engage in discovery by any other method if you're creative and you want to get things done. So keep that in mind, that really any way of getting the information you need. And my other point is just remember that discovery is a tool to help trial lawyers get the information you need to try your case. It's not an end in and of itself. You don't want to discover the case to death. You want to get the information that you need in order to go try the case or to settle it if you're going to resolve it. So that's my point on Rule 36.
Your Honor, if I can ask a question, do you think that the court would be more willing in this pandemic to authorize the parties to stipulate, for example, to the use of interrogatories?
Sure. If you want to stipulate to it, then yes. If you don't want, so that's always that's why I emphasize the rules is absent a stipulation, then no, because it's not authorized by the rule. But if you stipulate, maybe the parties think that using interrogatories works. I know I've stipulated as a practicing lawyer, I've stipulated to interrogatories when it was just a good way of exchanging information that made sense. Even for matters that are in state court. So yeah, that was my point. Stipulate to it if you think that's a good way to get answers, and it'll work both ways, of course.
So the next thing we're going to talk about is depositions. And as I noted, this is one area in which I think that Oregon's rules were ahead of the curve in terms of their ability to adapt to the current pandemic.
So I would say on Rule 39, the thing that struck me when I went back and looked at the rule is the rule specifically provides for a telephone deposition, which is obviously going to be useful during a pandemic. It doesn't specifically mention a video conference. And so that raises the question, can you do a deposition by video conference? I mean, it would seem logical if you've got a witness who's got the capability or is going to go into a lawyer's office anyway. Why not do it that way? Even though, again, not specifically stated by the rule, if the parties stipulate, then that's going to be enforceable, and go ahead and do it by video conference. There is a rule that we'll get to in a later slide that talks about remote location testimony. That's under ORS 45.400, but that's not a deposition. That's for testimony at a trial or at a hearing, like, for example, a preliminary injunction hearing where you may take testimony. You can do it through remote location testimony. That would be like a video conference, so you could do it by Zoom if you want, but not for a deposition. But with an agreement, you could. It seemed to me when I looked at these rules, under C4 of Rule 39, you can video record a deposition. If you can video record it and you can take it by telephone, then it seems to me it makes perfect sense to just do it by video conference so that the lawyer asking the questions can see the witness, and that will give you a good idea of how the witness will testify at trial.
I think that I got started taking video depositions a few years back because I was working on a FLSA collective action where there were opt-in parties from all over the country. And we were told by the court in that case, because it was the FLSA case, it was in federal court, the Fair Labor Standards Act. But we were told by the court in that case, we could not take any of the opt-ins depositions in person. We had to take them all remotely. And I had a lot of trepidation about that. I had never voluntarily taken at least a significant plaintiff's deposition, for example, remotely. And I sort of got thrust into it and forced to do it. And it does take some additional thinking about in advance about how you're going to plan, what you're going to do with exhibits. One of the things that I realized though, and I had to take about 30 plaintiffs' depositions in that case, and most people, the thing I was most worried about was cheating, was people trying to do improper coaching off the record. And I think that I was pleasantly surprised. I definitely developed admonitions to try and deal with those things. But the average person, I don't think was any more likely to try and use materials or try and engage in some type of thing that they wouldn't be able to do if I were there in person. So what I have come up with in terms of my cases that are occurring now is trying to get a stipulation ahead of time about how both sides are going to conduct their remote depositions. So, a stipulation that says nobody is going to communicate with the witness in any format when they're not on the record, whether it's showing that, texting them, emailing them, none of that will be permitted. And no materials are to be within the witness's view. So that was the big thing that was going on. In the couple cases I had where I thought someone was doing something improper, they had notes that were within their view, but which I couldn't see. And so I only found out about the notes through asking questions about, what do you have available to you? Where are your notes? Oh, they're sitting here next to me, and then asking them to put them away. I think the other thing it's really important for counsel to plan ahead of time is what are your expectations as to technology so that you can participate via remotely. Does the witness have high-speed internet? Do they have a camera? Those types of things. And I think getting on the same page early is important. If you can get a stipulation, which I see is in everybody's best interest. I mean, if someone won't stipulate that the witness isn't going to be coached, I don't want to waste our judges' times, but I feel like that's fairly uncontroversial request.
Yeah, I think a lot of the deposition issues are answered by the MBA deposition guidelines. And so, all lawyers should always, when you walk into a deposition, you should bring your rules with you and bring a copy of the MBA deposition guidelines. So if opposing counsel is giving you a hard time, you can show them, here, it's right in the guidelines.
If I could ask, if I could interrupt and just ask a question about that.
Sure.
I'm curious, sometimes in depositions, you may have an assistant who accompanies you, maybe to assist with the exhibits or for any other purpose to help prepare the case. If you're doing it by video, do you identify every person? If you're taking the deposition, do you identify every person who's with you in the room or joining the call? How does that handle? And what are you required to do? Can you have people sitting in the background?
I'll give you my take on it is I feel like disclosure is in everybody's best interest. I'll identify who's in my room and I expect the same thing, you know, whoever is participating to be identified by them as well.
And I think the consensus statement and the deposition guidelines that most judges follow provide for two things. One is that, you know, we have an open courts provision and a deposition is part of a court proceeding so that anyone can attend a deposition. Now, the exception, of course, is a witness. If they're going to be a witness, that's going to be excluded from hearing that testimony. You can exclude witnesses just as you can in any court proceeding. So, but aside from that, if you want to have an assistant, a paralegal, somebody else to help you, you know, I agree with Elizabeth. I just have everybody identify on the record so that there's no question. Because what happens, what can happen is at the time of trial, you may end up using that deposition in front of a jury, and the jury's like wondering, oh, who are these people and what's going on? And so if you've identified them, then there's no issue. And this slide we've given you just the email addresses of my clerks, because if you've got a dispute that comes up during the deposition and you need to get the court involved during, you know, it used to be you just called we have got limited staff available to answer phones during the pandemic. So email is much better. A lot of people are working remotely. So if you call, you may end up getting a recording and leaving a message. Whereas if you email, one of my clerks will get back to you right away. And then we'll find a judge available to hear the deposition dispute. So email, and you've got the email addresses right there for Caitlin and Suzanne, so they can help get your dispute resolved.
One of the issues I'm seeing disputes over in most of my depositions is a lack of agreement on exhibits, whether exhibits must be provided in hard copy for a witness and opposing counsel to review, or whether they can be simply displayed by the lawyer taking the deposition. For the most part, I've chosen not to raise this with the court because if it comes down to it and my opposing counsel is insistent, I'd rather just give them the exhibits, you know, ahead of time. But I definitely have had issues where either opposing counsel didn't provide them to me and then wanted them available printed out. So has the court had to deal with any issues about, you know, how are exhibits to be shared?
I haven't, but it's a really good question, particularly during the pandemic. Of course, most depositions are going to be done remotely in some fashion. So, you know, it's a fine line. So let's say you've got a good exhibit that you want to use, but you want to surprise the witness with. So if you lose the element of surprise by sending it to the opposing lawyer and saying, you know, here's my stack of exhibits, or if you try to bury it within the stack, that's not going to work either. So I think the element of surprise is highly overrated. And so I would err on the side of giving a stack of exhibits to opposing counsel. And so that way you can have a more productive deposition. If there's something that you really want to use to surprise, maybe you just save it for trial and don't even use it at the deposition. So, but otherwise, I think you'll have your deposition will go a lot more smoothly if the lawyers just share the exhibits ahead of time. And so you have the stack and you've got them appropriately numbered, so it's easy for the witness to find, you know, what exhibit number you're on. And also then they've got the full document. You know, if I was defending a deposition and the lawyer on the other side just wanted my client or my witness to testify about a document without seeing the full document, I'm not sure I'd let them testify. I'd say, you know, they're entitled to see the whole document before they give any answers, and put that one sentence that you may want to ask them about is, you know, put that into context.
The other issue that I've seen arising lately is this one on this slide about, I had a dispute, I'm in the middle of a dispute with counsel about this in a case where the plaintiff wants to appear at a deposition that's been noticed for video wearing a mask. And I was not able to get a stipulation from my opposing counsel on the protocol. And we actually began the deposition, and they did not tell me ahead of time that even though we had noticed it for video, the plaintiff would be wearing a mask. And the court reporter actually was the first person to raise it before we went on the record and said, I'm worried about audibility because I'm not in the same room and it muffles their voice. And the plaintiff's counsel was in the same room with the client. And so he refused to go sit in another room and log in via Zoom. He wanted to be in the same room with his client. And so they were both wearing masks. And I tried everything I could. I said, you know, he said they didn't have enough room in his office for them to sit in separate conference rooms. So I said, you could come, we could reschedule and you can come to my office and I'll give you 2 conference rooms. Or I can give you a huge conference room where you can socially distance and take off your mask. Or I'll set up a plexiglass shield for you, but I don't want to take the plaintiff's deposition on video while he is wearing a mask. And so we are, hopefully we'll resolve that dispute, but I'm prepared to take it to motion practice. I don't know if I would if it were not the plaintiff. I think that, you know, you basically deprived us of the opportunity to observe their demeanor. And especially where the court reporter is saying it causes problems hearing. So I'm hoping to resolve this one, but I think it is one where I would want the court to get involved because I understand the desire to be with the witness. I'd rather be with the witness too, but we all have to make concessions. And I think my position was reasonable enough. But of course, I'd like to hear the judge's perspective on that.
I don't have a good answer for that one because, of course, you have to comply with state law, and the governor has issued some orders about masks in business settings. Whether or not your deposition would be included within any of the governor's orders. Of course, if it was occurring in the courthouse, then everybody's required by Chief Justice order to wear a mask. So I don't think you'd get any relief there. So I don't know the answer. I would suggest, you know, I've used, here, I got one here, my face shield. See? You can wear that and you still see the witness's face. You might get a supply of those and consider, you know, obviously you're going to want to raise this ahead of time with opposing counsel. And anytime during the pandemic, you're going to just ask about masks. Or, you know, is their plan? Would a face shield suffice? We're videotaping it, so we want to see the person's face. Frankly, if I'm the plaintiff's lawyer, I kind of want the jury to see my client's face too. So I'm surprised that the plaintiff's lawyer necessarily gave you some pushback on that. But you know, it's a tough issue. And you know, the governor issued a new order last week, and things are changing rapidly as the numbers keep going up and up and up. I'm not sure where we're going to end up with masks at a deposition. Certainly, what happens at a court proceeding, you know, I'm on the bench. I just got off the bench in the morning call, and I wore a mask the entire time, and I'm talking to a whole bunch of people on the phone. Anyone who walks into the courtroom has to wear a mask. They don't lower it when they speak. So I think we have to get used to people wearing masks, at least in the short term. A lot of good news about the vaccines that are coming. So hopefully we'll be over this fairly quickly and this won't be an issue. But for the next few months, I think it is.
Your Honor mentioned earlier other types of mechanisms for taking discovery, and we've included a slide on ORCP 40. I'd like to hear from Your Honor about this. I will tell you, as a defense lawyer, my greatest concern is if I have a question that's subjective. I practice employment law. You know, why did you think your supervisor's motive was your sex? Allowing my concern is that the answer will just be written by the lawyer, and I won't get the witness's take on it. But I'd like to hear from Your Honor about this mechanism.
I just included this slide to let people know that this is a tool that is available under the rules. Now, it's rarely used. I never used it as a practicing lawyer. If you take deposition by written questions, then the argument would be you don't get to do an oral deposition. You get one deposition of a witness. And so if you did it in writing, you know, I would only do it if it was something, you know, for example, if you needed a witness to authenticate some records so that you can get them in under the you know, the business record exception to the hearsay rule or something like that, where it's very narrow and discreet. But otherwise, I wouldn't do it by written question. I think it's unwieldy, and as Elizabeth says, you're just going to get the lawyer's answers and not the witness's answers. So, for something small, it's a tool that's available, but I'm not urging you to start down this path.
ORCP 43, production of documents and things. Obviously, we've long been using these. Do you think we'll see an uptick in parties trying to get what they need through document requests as opposed to, you know, depositions?
You know, we have a lot more electronically stored information, and the rule specifically addresses that. And that's going to be fruitful grounds for some disputes over discovery. The other thing that parties, you know, they have the right to inspect documents, and so if there's something about the authenticity or the legibility, you can insist on, you know, I have a right to see the original. I get to inspect that original. Now, most of the time, and particularly during a pandemic, you can get good copies of all of the documents, and a copy is just as good as the original, and that will suffice. But in the rare instance where you need to see the original, that's available for you. Again, I put this rule in just as a reminder to go to the rules first. That's always. I can't tell you how many times as both a lawyer and as a judge where someone would ask me a question and I'd pull out the rules and lo and behold, there's the answer. So I'm, again, a believer in following the rules and encourage lawyers to use them.
The next thing is ORS 45.400, which Your Honor mentioned earlier about remote testimony.
Yeah, this is, so this applies to remote location testimony. You can file a motion and you can, of course, stipulate to that. And you have to give notice. There's the procedure. The rule talks about you have to give notice at least 30 days before the trial or hearing at which the testimony will be offered. So to me, that they're talking about a court either for trial testimony or for, you know, something like a preliminary injunction hearing or something like that, where or maybe a prima facie hearing where testimony is going to be offered, not for a deposition. And I note here that it says the court may allow that that you have less than 30 days if there's good cause, and it doesn't really give a standard for when the court is to grant these requests. It just says you may move. The Chief Justice order that applies during the pandemic, that's Chief Justice Order 20-016, it's a very long, I got it right here with me. It is a long 16-page document with some exhibits attached, but in paragraph 8 of that document, it does say that the pandemic alone means that good cause exists to allow remote testimony unless there's a presiding judge order that says, you know, there's a reason not to allow remote testimony. So like the prejudice outweighs the good cause. And that can happen. There may be times where you just need the person to be there in person. But that's, I think, pretty rare, and especially during the pandemic, if you've got a court proceeding where you're going to be offering testimony, I think remote is fine. As the numbers keep skyrocketing, the governor keeps sort of restricting what can happen in our society. The Chief Justice is reacting to the governor's orders. We're going to get a new Chief Justice order probably sometime this week to kind of cut back on some of the things that currently are allowed. I've got a conference call tomorrow about that very issue. So, you know, lawyers just need to get used to doing things remotely. And some of these things, once you do them a few times, you'll see that it works just fine. And it may be that you're, even after the pandemic is over, you may want to use these tools because they're authorized by the rules. So there you have it.
So, Your Honor, one of the things that I think about in terms of remote testimony, especially for a jury, because I had a case that was scheduled to go to trial during October, and it got moved out. But one of the things that my opposing counsel said was, let's just have everyone testify via video conference who is in another location. And as defense counsel, I was representing, you know, a national company that would have had to bring people from all over, whereas the plaintiff and their client were present physically in this jurisdiction. And so they didn't have those travel concerns. And, you know, I think the subject that was most on my mind was, you know, I've seen a jury watch videotape testimony and just about fall asleep because they're so bored by it. They're more engaged by a live human being in front of them. And so I worried that having so many of my witnesses be via video would affect their ability to, you know, affect the sort of credibility and sort of connection with the jury when they're, you know, explaining things. So does that sort of, you know, the burden of remote testimony falling more on one party than the other, do you think that holds any water?
Well, I think, you know, if the answer is, I mean, I think that the same rules ought to apply for everybody. So if you're going to have witnesses testify remotely, either you have an agreement that, you know, these witnesses they're kind of, you know, peripheral witnesses and they can all testify remotely. And then these are the critical witnesses that will need to testify in person. Or you can have agreement that everybody's going to testify from a remote location. Even the local plaintiff, they're not going to be in the courtroom. They're going to be in their lawyer's office or wherever and testifying remotely. I agree with you that the videotaped testimony can be mind numbing for everybody. And so if you have to use that, which does come up, make sure you edit tightly and try to keep it to a minimum. But remote testimony by video conference, I think, is different. I had a trial where someone was testifying from Mexico City by video conference. This was quite a few years ago, 8 or 10 years ago now. And it worked just fine. And the jury kind of, you know, they could see that the person was actually just talking in response to questions. And most courtrooms, you know, we allow juror questions. So if you've got a witness who's testifying from a remote location, but live, then you can, you know, jurors are engaged. You can say any juror questions for this witness, and the jurors will submit their questions and the judge will ask the questions. And then it's very much like live testimony. I would be less concerned about that than the videotape testimony. Okay, I included a couple of blurbs from House Bill 4212. This was passed in the special session just recently to give the courts and other things some relief during the pandemic. This first slide, I don't think really applies to anything that you folks probably deal with unless you're dealing with public meetings of governing bodies. They can do it by video conference. That's expressly allowed by House Bill 4212. I think maybe the next slide. Yeah, this slide will be more relevant to you. So Chief Justice, the section 6, sub 4, sub A, Chief Justice may direct or permit any appearance before a court to be by telephone, other two-way electronic communication device, or simultaneous electronic transmission. The Chief Justice has permitted that in her Chief Justice Order 20-016. So this divides the world of court proceedings into a number of categories. So category 1, essential proceedings, are ones that have to be in person unless the presiding judge says otherwise. Category 2, essential proceedings, may be by remote, and so that's authorized by the Chief Justice, but it requires the authorization of the presiding judge. And then category 3, it just remote, can be remote. You don't need a special authorization by the presiding judge. And that includes things like case management conferences, temporary restraining orders, and things that are in category 3, essential proceedings. Paragraph 5 of the Chief Justice Order says motion hearings can be remote. That's specifically authorized. And paragraph 6 applies to other court hearings, court proceedings. That's also specifically authorizing remote proceedings. So the Chief Justice, in that very lengthy Chief Justice Order, has permitted appearance for a variety of court proceedings by remote means. So I think that's the way it would be. Now, there's the exception that you see in subsection 4B. If there's a particular reason why remote isn't going to work, you need to go to the presiding judge and ask the presiding judge to order that the appearance be in person. Basically, you're going to need to, in this county, you're going to need to convince me that there's a particularly strong reason why that person needs to be there in person rather than remotely, and it's worth the risk, because every time we bring someone into the courthouse, we're running a risk. And given the numbers, my first concern is not how effective you're going to be in presenting your evidence. My first concern is to protect the public and protect court staff, lawyers, and the public from infection of the virus. So not to say I wouldn't order in-person appearance, but it would be an uphill burden.
Dan, we are going to move into the part of the presentation on the impact on jury trials and jury selection. So if there's any questions on discovery or what we've covered, let us know.
There haven't been any additional questions so far.
Okay, sounds good. So we wanted to talk about the impact on trials, and I think sort of the news this morning and last week about vaccines, it's a very fluid situation, and hopefully we will be in a situation where things can be more normal, if not completely normal, in 6 months time or so. But when all of this started happening with the shutdowns, I started looking at what courts were doing with trials in particular, because I had a couple of trials that were imminent when the shutdowns began. And obviously, I think everybody knows that there are criminal trial precedents issues that are paramount, but I've also noticed an uptick in courts trying to persuade parties that a bench trial would be just fine. And there are obviously courts that have decided there aren't going to be any trials this year. Southern District of New York issued that type of order and is only setting trials in winter. And then in my research, I found there are other courts that are adopting all sorts of procedures. It just sort of depends where you are. The Minnesota state courts have a detailed application where the presiding judge of that county, chief judge of the county, can fill out an application to the Office of the Courts to be authorized to reopen. If anybody's interested in those materials, I do have them. But obviously, I think everyone would love to hear from Judge BUSHONG on the sort of delays that we're experiencing.
So included in the materials, I think, is the jury trial policy during the pandemic that I adopted for Multnomah County Circuit Court about a week ago. This came up, I had published in the Multnomah Lawyer an article. I had spoken at various CLEs and tried to get the word out to the bar about where we were at in terms of civil jury trials during this pandemic. And I decided at the request of the court's executive committee to actually turn what was my article that was in the Multnomah Lawyer to turn it into a policy so that people could see, you know, here's what it is. And so the gist of the policy in terms of civil cases, and it also addresses criminal, but the gist of it is that unless there's an awful good reason to have a trial right now during the pandemic, knowing that that requires me as the court to use the power of the state to bring people in to serve as jurors and sit in an enclosed room, which is what a trial would be, for a number of days, whether it's 2, 3, 4, 5 days. That's the very scenario that the Center for Disease Control says is the highest risk of spreading the virus. So there may very well be reasons why a trial needs to happen under those conditions now. But those are going to be the exception, not the rule. The rule is basically we're going to most likely be setting trial dates. And I'll give you a trial date whenever you want. For those of you who've been in front of me for scheduling conferences, you know, if you've got a trial coming up in the next, you know, in November or December of this year, you should have a scheduling conference with me because that trial's most likely not going to happen. And pick a date that's going to work for you. Now, what date should you pick? Well, you tell me. I'll give you whatever date you want. You want to pick a date in January? Okay, I'll give you that date. Is your trial actually going to happen in January? I'm guessing not. Probably not. Is it going to happen in February or March or April? Well, you read the news. They're talking about vaccines coming out and starting to be available to the public by the end of the year. The spring, we may very well be in a situation where we're trying civil cases, certainly by the summer. I've been telling people spring or summer, I expect that we're going to be in pretty good shape for trying cases. There's going to be a pause. I mentioned this earlier that given the governor's freeze from last week, the Chief Justice is working on an order. I have a draft of it in front of me, but it's not final yet, so I can't share it with you. But essentially, we're going to be in a pause mode for at least as long as the freeze lasts, which for most of the state is 2 weeks, and for Multnomah County is 4 weeks. We're not going to be having any civil jury trials during that period of time. And we're not going to be having hardly any, if any, criminal jury trials during that period of time, unless we have someone who's up against a statutory or constitutional deadline that we just have to try the case. Then of course we'll try it. And we can try cases during the pandemic if we have to. We've done 2 already, both in the old courthouse. I feel more comfortable doing them in the new courthouse because we have an updated HVAC system. The air circulates, it's clean, the ceilings are high, there's more space. I feel more comfortable, but still not to the point where I want to order people from the community to come into the courthouse, go through jury selection and sit through a trial when I can postpone it. And so, and I think Elizabeth, in some of the later slides, will talk about some of the things that courts have been thinking about. But here's the serving on a jury, not really at the highest level of comfort based on this survey. And we hear this from we're bringing in people to serve as grand jurors. Our grand jury process is ongoing, and so we go through a grand jury selection process. Judge Albright runs that process, and she hears it from the jurors. They get, okay, once you understand what a grand jury does, and it's indicting people for felonies, and that has to be done by constitutional requirement, they get it. She still excuses a lot of people because they're not comfortable. They're in a high risk category. But people understand that for a jury. And so the two trials that we had were both in custody defendants in criminal cases. And we did everything we could to maintain social distancing and required masks and face shields and frequent cleaning and sanitizing of the areas, and did everything we could to keep people safe. And jurors understood. One case was, I don't think the jury quite understood. A defendant was charged with robbery. I think he was a homeless person, and he pulled a knife on somebody, went to their door, pulled a knife, robbed them of a block of cheese. And some of the jurors afterwards, and they made comments to the press that they were willing to serve as a juror if it was really critical and really important, but they didn't see how stealing a block of cheese kind of was that important. They didn't quite, and of course, jurors don't understand the sentencing. A robbery with a deadly weapon is a Measure 11 crime that subjects the person to at least 70 and sometimes 90 months in prison. So it is a pretty serious crime. And this person had been in jail for a long time awaiting trial. So the jurors don't necessarily know that. But those are the sorts of things that jurors understand and they're willing to serve as jurors on. If, the run-of-the-mill civil case, I love civil trials. Don't get me wrong. I love all civil trials. I liked them when I was a lawyer, and I like them as a judge. Whether it's a simple personal injury case to a complex business dispute, I like trials. And so for me, they're all really important because this is how we resolve things in a civilized society. And I want to have trials. And I think they're interesting and I think they're important. But a juror, I heard this from jurors even long before the pandemic. I talked to the jurors afterwards in almost every case. And if it's a civil case, personal injury case, I heard from jurors all the time saying, why couldn't the people resolve this? Why couldn't they work this out? Why did they take, 3 days of my time to hear this, soft tissue injury in a fender bender car accident case? They were kind of offended that it took their time. And so you see these statistics about reporting for jury service. If it's not something that's really all that significant, and jurors often will think, especially during the pandemic, this could have waited. And in many instances, they're right. It can wait. It can wait till vaccine news is very promising. We'll be back up and running before you know it. And I get, as I said, I love trials. I believe in the importance of the jury trial system. And I get that there are lawyers, their livelihood and their practice depends on getting their cases to trial when necessary. And it's a real hardship for lawyers, for clients, for everybody involved to have this pause on civil jury trials. I get it. I don't want it to be that way, but it is that way right now. So I've talked a lot about that. I let people ask questions, or Elizabeth, you can weigh in too.
One of the things I want to highlight here, as a litigator, I found this National Center for State Courts poll from June to be really interesting. It's if anyone would like a copy, let me know. But they did this poll in June where they asked potential jurors, and obviously, as the judge pointed out, serving on a jury was something they remained uncomfortable with. And I think that for me, part of what was striking about that was how comfort levels may affect who is willing to show up and serve or who might request a postponement. This is part of that same study. And, you know, it shows that most people who are 74% of the people who responded who are under 50 said they would serve. But 53% of people over age 65 said no. So obvious that they don't want to serve. And so, you know, even if you were to decide to try and hold a jury trial, what is that doing to your pool? There's also the issue of women who, you know, I don't think there's any key numbers on this, but it's something that the study touched on was, you know, if women have been affected by disproportionately being affected by caregiving, are they going to not be as willing to serve right now if they're caring for someone who is either, you know, elderly or at risk, or they have to be caring for their children? People of color are also statistically more likely to be affected by coronavirus just because of the healthcare structure that we have. And so if we forge forward, what does that mean for who's going to be on that jury? This study is really interesting for that reason. I don't know if the judge has any thoughts about, you know, representation on the juries, but I found that really interesting.
No, I do think that's really interesting, and it does raise the question of whether you're going to have a really representative jury panel. I'm concerned about that for criminal cases, of course, because that could be the basis for an appeal. Civil cases, you know, I would get the parties to stipulate, if we were to have a trial, that they're waiving any objection to the composition of the jury panel. And if you're not going to stipulate to that, then you're not going to have a trial. So if you want a trial, you better stipulate. And then, but the one thing I would say is keep in mind, you know, some people don't think about it from the juror's perspective. Most civil cases, not all, but a lot of cases, the issue is negligence. Failure to exercise reasonable care in response to a reasonably foreseeable risk of harm. That's the issue in many, many civil cases. And if you're a juror and you're sitting there going, well, why is forcing me to be here for 3, 4, 5 days when we know that there's a reasonably foreseeable risk of harm because of this pandemic? I would be worried that the jurors thinking more about that than about the trial. Now whether they'll make the plaintiff's side pay or the defense side pay, I don't know. I don't think I'd want to try the case under those circumstances. I'd wait, and as a trial lawyer, I would say, let's wait till that's no longer a concern, and then we can have a real a representative jury panel who's focused and willing to serve and wants to serve, and I think you'll all be better off.
The one of the things that I gathered when I was trying to look into how courts were handling this was use of juror questionnaires. And so I think that juror questionnaires will be useful not only in the short term, but in the long run, as we're trying to figure out who might have some type of susceptibility to the virus. There was in the Northern District of Texas, there is a court that decided to go forward and try a case, and it used juror questionnaires, I think, in a really good way, where it solicited information. You know, are you an essential healthcare worker? You know, are you caring for somebody who is, you know, in an at-risk population? And they sent those ahead of the trial, and they got, of the 99 questionnaires they sent, they got 78 responses, and then they were able to use those ahead of time to excuse people from service without ever having them come in. They also, when they ultimately did hold the trial, they decided to do staggered juror reporting so that you would only have like 12 people in the veneer for consideration at any one time. If anybody would like to see that juror questionnaire, I do have a copy of it. It's generic. It can be used in just about anywhere. It's entirely focused on coronavirus. So I thought that was a really good idea. And frankly, I'm going to be asking, you know, for it in any trial that I do, because I just don't see a downside to getting that information so that we can protect everybody. The other thing that this court in Texas did was they provided PPE during the voir dire, which consisted of, and this is a picture from the courtroom where they did it. They gave people temperature strips, mask and face shields. They gave them wipes. They conducted voir dire in this sort of setting. They used, they seated additional alternates. And that is something that I would also want to ask a court for is, you know, if we're going to start this trial, could we please seat at least double the amount of alternates? What's your take on that, Your Honor?
So like I said, we've already done 2 jury trials during the pandemic, both in the old courthouse. We're prepared. We've got a plan for how we conduct jury trials. And it involves all of these things. The jurors don't sit in the jury box. They're spread out throughout the courtroom. They don't deliberate in the jury deliberation room because you can't maintain social distancing and have 12 jurors in there deliberating. So we have to set aside another courtroom and jurors go into that courtroom to deliberate. And of course, by Chief Justice order, masks are required. The order does permit a brief, and emphasis on brief, lowering of the mask to during witness testimony, and judges are authorized to allow a juror during voir dire, again, briefly, just for a few minutes, to lower a mask so that people can see their face when they answer questions. But that's it. If you're unwilling to allow that, you're not going to have a trial because that's required by Chief Justice order. The other thing we learned from, and we're planning for additional trials as we go forward, the other thing we've learned is it takes a lot of space and it takes a lot of time because, you know, pre-pandemic, we would, every Monday, we'd bring in 200 jurors from the community and sit them all together in the jury assembly room, and we'd fill, you know, 10 or so juries to start their jury trials that Monday, and it was no big deal. And I saw the question in the trials that were held, have jurors raised the fear of COVID? Yes, but not as much. And keep in mind that those trials were in, I think one was in April and the other, they may have both been in April. So it was fairly early on. And I remember back to those days when, you know, our daily COVID numbers were approaching 100 and we were really concerned. Well, now they're over 1,000 every day. And so, you know, the world's different now than it was then. And so there were concerns. There were jurors who were excused because they expressed a concern, and the judge said, you know, you're of a certain age or in a high risk category. I hear your concern. I want you to focus on the trial if you're seated as a juror. So I'm just going to excuse you. We had to excuse a lot more jurors. And then I just so you know, and I gave you the policy, but in terms of how we conduct the trial, as I said before, I love civil trials, and I wish we could do more of them right now. But I have to run the whole court, and I am really concerned about the number of people that I have sitting in jail right now, awaiting trial on a serious felony charge, and had been sitting in jail for more than a year. Now, keep in mind, these people are innocent until proven guilty. There's a presumption of innocence. So if you were charged with a serious crime and you were held in jail for more than a year and you were insisting that you were innocent and you want a trial, you know, we've put those off as much as we can. If I'm going to have a trial, those cases are going to come first. And I've got a number of them in some very serious felony cases where they've been waiting in jail for their trial. Those cases are going to come first. So that's why they're prioritized in my jury trial policy. Frankly, given the space that's required and the difficulty and the time it takes to actually pick a jury, I can probably I know I can do 1 trial a week, and I can probably do 2. If I had to do 3, I might be able to do it. I don't think I can do more than 3. And so those are going to be criminal cases. The civil cases are, unless there's a good reason, and there is under the policy, if there's good cause for having a trial now, I don't know what that is yet. I'll hear the arguments. So far, almost every case when I've had a scheduling conference with the lawyers and I tell them, you know, here's your options. You can have a bench trial. I can do a bench trial right now if you want. If you don't want a bench trial, you want a jury trial, then it's going to get set over to the spring or summer unless there's a really good reason why you have to have it now during this pandemic. And the lawyers have all been, you know, we're fine with setting it over to the spring or summer because we can't articulate a really good reason for having it during the pandemic. I've had a couple cases where the plaintiff's lawyer said, you know, my client's dying and would like to have a trial before he or she dies. I've got one of those cases set for trial in January, and I told the lawyers that trial's going to go. We're going to have that trial unless it settles. So we will have a civil jury trial in January unless that case settles. But something short of that, you know, you'll have to tell me. I can't envision all the possible reasons why it would be so important that we have a trial and put jurors at that risk. But there might be. I'm going to keep an open mind. I'm willing to consider that. So feel free to set a scheduling conference and present your case.
Thank you, Judge. We're past the 1 o'clock hour. I don't know if there's any concluding comments that Judge Bushong or Elizabeth, you wish to make at this point. Otherwise, this will end our program.
I think that it's a very interesting time to practice law. I was excited to hear about vaccines, and I'm assuming, you know, we're gonna feel the effects of this for a while. And I really appreciate the judge sharing his thoughts.
And I would just close by saying this challenge of this pandemic is bigger than all of us. We're all in this together. You know, our survival is at stake. We need to be smart. We need to protect ourselves, our clients, and that may mean postponing some things for a while. I know that causes hardship among lawyers and businesses and clients. I wish I could avoid all that, but we can get through this. I need your help. I need the bar to work together to keep moving your cases. Move them to resolution if you can. I've got judges ready, willing, and able to do settlement conferences and help do motion hearings or whatever it takes to keep these cases moving so that once we get out of this pandemic, those cases that need to go to trial, we'll try them. We're going to try them all. I can call on the help of retired judges if I need to. I got plenty of judges. I got plenty of room in this big, beautiful new courthouse. We'll try your cases, but we got to get through this pandemic, and I do need your help. And I appreciate your patience and cooperation, and we can do it. We'll get through this.
Thank you, Your Honor. Thank you, Elizabeth. We will now take our 15-minute break, or actually it'll be about 13-minute break before our next session with Rocky Dahlem. Thank you.
Thanks.